his statement. And I now give the floor to the representative of the Russian Federation.
Thank you, Mr. President. We are grateful to the leadership of the International Residual Mechanism for the report on the activities of the body. We are carefully and closely following its work, including all of the judicial proceedings which are underway. The proceedings of the mechanism in the months that have elapsed since the previous briefing, judging by the report, have largely stalled. The nature of this is increasingly reminiscent of the ICTY in the bleakest hours of its existence. Of late, we have observed with alarm the somewhat chaotic reshuffling of judges, specifically the leadership of the appeals chambers. All of this chaos has deep roots that can be traced to the reckless approach to the judge's appointment procedure for the Radovan Karadzic and Ratko Mladic appeals. The Security Council and the General Assembly, as is known, have filled the judges' roster with a host of new names. However, the leadership of the mechanism continues to have an impact on the trials, chiefly of those who worked under the ICTY. Hence the origins of the problems that have arisen. We have studied what is openly accessible, namely the latest rulings of the mechanism on the Mladic and Karadzic cases. It appears that in the heat of the procedural wrangling and the settling of accounts, the heads of the mechanism lost sight of the fact that in their hands are human fates, the fates of individuals expecting equality of justice. At the same time, it is proposed that the Council merely resign itself to waiting yet another few months for the Karadzic verdict, for the new judge presiding over the chamber to become familiarized with case materials. Our hope is that he will not require as much time for familiarization as was necessary for the corresponding judge during consideration of the Vojislav Šešel case. We have taken note of the Judge Johnson's ruling not to refer the contempt of court case to Rwandan authorities. As we understand, he believes that there is a strong likelihood that this trial will begin and conclude more expeditiously if it remains under the mechanism. We do have hope, but we shall see how this bears out. Questions also remain as regards access for the accused to timely and appropriate medical treatment. We continue to be alarmed at the negligence vis-à-vis Ratko Mladic's health. We have repeatedly called for a qualitative examination and treatment for this individual. We repeat that if this is beyond the ability of the mechanism's prison doctors, then Mr. Mladic should have been duly released for purposes of treatment either in Russia or Serbia. Once again, we drew attention to the section of the report on the residual mechanism's assistance in capacity building for national jurisdictions, conducting criminal prosecution for war crimes cases. It behooves me to note that such a mandate does not exist in the constituent documents for the prosecutor. This is all the more true for the relevant work of countries that have nothing to do with the situation of which the residual mechanism is seized. Once again, we urge that the mechanism cease improper expenditure of funds and the use of staff allocated to it. We expect that it will not divert its attention towards tasks not assigned to it under the statute, rather that it will focus on expeditiously and effectively discharging its mandated functions. Thank you, sir.
I thank the representative of the Russian